Herlig, I want to welcome my good friend Catherine Zappone, Minister Zappone, to this House, and I want to indicate at the outset that, having listened to the speech that was given here earlier by Minister Harris, every word of it is something with which I agree, and every line of it is something which I think the public should be aware of, and I'll come back to that in a moment. I want to make a second point. I think that this referendum is by no means a foregone conclusion as to its passage. And I want to say that it is the middle ground of Ireland to which those who, like myself, favour repeal should address ourselves in the coming weeks. And therefore I echo what other speakers have said about the need to have a reasoned, calm and persuasive debate, and also to roll up our sleeves to achieve this. This is not like the situation that arose in relation to the marriage equality referendum. This is quite different. The extent and depth of opposition and the issues involved are radically different. There are some similarities, but there are significant differences, and it will not go through on the nod, and it requires to be delivered politically in a rational, calm and decent way that brings Middle Ireland with the proposal. And in that context, I just want to say one thing. Words were spoken here about the Catholic Church in the 1960s and the abuses of children and the like. We cannot make the Catholic Church the enemy in this process. There are many, many good people who have devoted their lives totally to the Catholic Church, and they shouldn't be forgotten. Secondly, I want to say this, that those members in this House who are opposed to this referendum, they aren't anti-democratic if they vote against having a referendum. And I ask this House to remember in particular those who, I believe, wrongly said that they would allow the bill to abolish this House to go through, but only so that the people could have their say on the matter. That isn't the process. The Constitution remains the same until the Oireachtas proposes a change to the people. And if you're opposed to a change, you're entitled to vote against a change. Now, I just want to say one other thing. Others here have spoken extremely eloquently in relation to the dilemma of girls and women who find themselves having to make the decision whether or not to procure a termination of their pregnancy. But I want to emphasise one thing. If you look at Article 40 of the Constitution, and sometimes people don't actually look at the Constitution as we heard today, but if you look at the Constitution carefully, it is an article to do with personal rights. And the issue here is not whether a fertilised ovum in a petri dish, in an in vitro fertilisation clinic, is a human life. In one sense it is, in the same sense that an acorn is tree life in one sense. But an acorn is not a tree. And likewise, a fertilised ovum is not a person, a human person, from most people's point of view. It is the means whereby a person could, after a pregnancy, come into existence. And the reason that I mention that is we're dealing here with personal rights. And I believe that the mistake that was made and the error that Peter Sutherland counselled against in 1983, the mistake was to create an absolute black and white description of the distinction between potential life and a human person in circumstances where, as the leader has just said, there is a grey area. Can I also say that I believe very, very strongly that once the possibility of pharmaceutical abortion, pharmaceutical termination of pregnancy came about, a totally different situation was created. The state cannot, in fact, prevent it. And the state cannot really, realistically, put people on trial for getting such a tablet online or administering it to themselves. And we have to face up to a situation whereby we face the truth of what the Article 43.3 has done to us. Let's remember that in the X case, a victim of a rape was told by the Supreme Court that according to the Article 43.3 as it originally stood, she could be restrained by injunction from travelling out of the state to have an abortion in Britain, and that it was only the fact that she was suicidal that overrode her right to travel to Great Britain. That was what the X case was about. And I remember in particular my good friend, the late Adrian Hardiman, when he was a barrister at the time, saying on television that travel injunctions would follow from the Eighth Amendment if it became law. And he was told by a leading academic, who I won't mention now, but you can all guess who it is. He was told that this was fanciful and was effectively a scare story. But it came into existence in the X case decision. The Supreme Court said there could be travel injunctions, and the only thing that could override it was to avoid a threat of suicide or another threat to the life of a mother. Now, I just make that point here because I think it's important that we put into place in the Constitution what I consider to be, in retrospect, a fundamental untruth, and that was that the fertilised ovum, or after 4 weeks, a group of cells which are the size of your fingernail, or after 8 weeks, maybe the size of a finger, is a person with exactly the same rights as a mother, and the only circumstance in which one can prevail over the other is if there is a threat to the mother's life. That was creating, I believe, a constitutional untruth. And can I go one stage further and say, the excuse that was offered by that prominent academic and all those who supported the 1983 referendum for bringing it in is that we could not trust the judges not to impose in Ireland a Roe and Wade outcome. And now they're saying you can't trust the politicians either. Well, who can you trust if you won't trust the organs of a democracy to deal with a complex situation of this kind? So can I finish then by simply saying this clearly? This referendum is not a foregone conclusion. It cannot be left to the extremists or the most ardent people to make the arguments. It is to the middle ground that the arguments must be addressed, and it must be by people who sound reasonable and supportive and confidence building to those who occupy the middle ground in the coming debate. And the arguments that are, in my view, very, very strong for appeal, and they go the whole way back to Adrian Hardiman and Peter Sutherland and all the rest of it as to why the Eighth Amendment was a mistake. Those arguments are very, very valid, but they have to be articulated in a way that brings people with them. And if we can't trust the judiciary as a democracy, and we can't trust the politicians as a democracy, and we can't even trust the women of Ireland in relation to the choices they must make, who are we to trust? And I believe we should have the courage to stand up and ask the Irish people to trust themselves, to give to the politicians they elect and the judiciary that they have indirectly appointed the control and the right to legislate in an area which is grey and in an area which, if it's dealt with as black and white, produces falsehoods, injustice and cruelty on occasions. And to those who say that Savita, and I have to say this in relation to what Senator Mullins said, that Savita Halappanavar's position was simply to do with sepsis, it was not. Because if it was simply that, and I make this point, what were they doing monitoring fetal heartbeat? Why was that relevant to the sepsis issue? It was more than that. Okay. Thank you very much.
Thanks, Senator. Senator Kelleher, you have 8 minutes.
I'm speaking today in support of passing the 36th Amendment of the Constitution Bill. I'm supporting its passage, and I hope you will too. I support this bill because 35 years after...
Speaking to the section has two effects. Firstly, it has the effect of inserting the wording in the schedule, but secondly, it has the effect of removing the existing wording of Article 43.3 of the Constitution. And in the ordinary course of events in this House at second stage, the time available for each speaker is naturally limited to 8 minutes, and that's to ration out time fairly among us all, and I've no problem with that. But there were a few points that I made yesterday evening that I felt I'd like to develop a tiny bit in relation to Article 43.3, which we're taking out of the Constitution if we pass this legislation, subject to the decision of the people. Firstly, I made the point that Article 43.3 in its original form was inserted into the fundamental rights section of the Constitution into the article headed personal rights. And that in those circumstances, we're dealing with what I believe was I'm not going to use that phrase, a misguided attempt to say that a fertilized ovum, either prior to implantation or post-implantation, amounted to a person. And in my view, and I just want to put it on the record of this House, that is not so. And nobody in this House really believes it is so. If we did believe that a fertilized ovum in an IVF laboratory where they're trying to assist a mother and father who are having difficulty in having children was a person, if we really actually believed that, there would be all sorts of different laws and things to be done if one ovum was selected or whatever. If we really believed that that was a person and the others were disposed of or put into nitrous oxide to be frozen, if we really believed that there was a person in that tank, that's one thing, but none of us actually do accord the status of a person to a fertilized zygote at all. So constitutionally, we are in a grey area, and it was, and this was the problem with Article 43.3. It decided to oversimplify the issue and to elevate the unborn, which it didn't define, to the position of person, and in doing so say that the right of life of a zygote, once implanted, as was later decided by court decision, was equal to the right to life of the fetus's mother. Now, I don't accept that proposition. And I believe that that was a falsehood and an oversimplification which was put into the Constitution without working out precisely what it meant. And that was done in 1983, doubtless in good faith, but it was done principally because the suspicion was that our judiciary would do a Roe and Wade and introduce abortion as a constitutional right, and that the judiciary were not to be trusted at the time. You then go on to 1992 and the X case. And let's remember, the girl in the X case was the victim of a rape. The girl in the X case was told by the Supreme Court that she could not leave Ireland for the purpose of having an abortion unless her life was under threat, not the rest of her life. She could not go to England, and her parents could not arrange for her to go to England, and an injunction was available to prevent her going to England to have an abortion. A rape victim, young rape victim, was told that the meaning of Article 43.3, as it then stood, was that she could not have an abortion. And that meant, and let's be clear about this, because I'm particularly addressing the senators who are conservative on this issue, and I fully respect your rights to be conservative, and I don't think it's in any way undemocratic for you to vote against this if that's your point of view. But it meant that in Irish law, rape victims, once the implantation had taken place, were obliged by the Constitution to carry that conception to full delivery by virtue of Article 43.3 as it stood, unless they could prove in the case, as was done in her case, that there was an imminent threat of suicide if she wasn't allowed to have an abortion. But the idea of travel injunctions was enshrined by the Supreme Court in the X decision. So let's not forget that point. And then in 1992, when all of that became apparent, the Irish people were horrified by the result. And Taoiseach Albert Reynolds put to the Irish people 3 propositions. And he allowed, which was curious at the time, but I mean, it was probably just as well in retrospect, but it was objected to at the time. He allowed 3 questions to be separately decided by the people. The first was, should suicide be a ground for termination of pregnancy in Ireland, which the Supreme Court had said it could happen here, right? The second was, should anybody be the subject of a travel injunction, again, by reference to pregnancy or the intention to procure an abortion abroad? And the third proposition was, should anybody in Ireland be denied information, because we had all the student publications and SPUC and all the rest of it at the time, should it be a crime to tell anybody in Ireland about whether abortion was available outside of Ireland? Should it be a crime in this country to tell somebody that they could, in the case of Ms X, actually go abroad and obtain the services of something like the Mary Stopes Clinic in England or whatever? And the people said, and let's remember who opposed what at the time. The people said to the first proposition, suicide, no, we're not going to have the situation that somebody will commit suicide and it'll be held that was something that you allowed to happen by your vote in the referendum in Ireland because abortion wasn't available in Ireland. So they rejected that leg of the 3 points. They voted to allow people to leave Ireland for the purpose of having an abortion. Now, I stopped there and asked Senator Mullen and others through the chair, respectfully, if really we believed that an implanted fetus had the same rights as anybody else, would we allow, as a born child, would we have amended our constitution to allow parents to take that child to a clinic in England to have it killed? I just make the point. And I mean, you may all have your views about the answer to that question, but my view, and I'll only express my view, my view is very definitely that that was a clear indication that in Irish people's minds, this was not a situation of unequal right to life. They were subjecting it, they were subjecting the right to life of the unborn to the right to life, the right to travel of the mother from abortion. So this was a qualification of the idea of equality.
In the final debating tradition, will you give way since you mentioned me?
Well, no, this committee stage. Sorry, can I
it's through the chair here, Senator Mullen, as well as everybody else.
Can I just make one point? We are at a committee stage. People are entitled to come back in again and again and again. So I'm not denying anybody a right to speak.
And just reminding people that we have had 5 contributors so far and 10 more on the way at least. So,
yeah, I know. Well, sorry, I want to make a few points, if I may, because
I'm certainly allowing you to make the points. Don't worry.
So, I mean, I believe that the Irish people, by adopting the freedom of information and the freedom to travel amendments to reverse in part the Supreme Court's decisions and the Court's decisions in respect of the original Article 43.3 were qualifying the idea of equality at the time. That's what I believe was actually happening, fairly viewed. And even when all of that was done, we then have had a succession of cases, some of which I was involved in as Attorney General, others as a barrister, and I don't want to deal with them because I don't refer to cases I was involved in, but some cases where Article 43.3, notwithstanding the changes that had been made, affected, for instance, the position of a child in care, whether the Irish courts or whether the Irish health boards could facilitate such a rape victim in care in going to Britain. And there was huge criticism at the time, and some of the opposition to the court's decisions at that time came from the pro-life movement, and they were entitled to express their views, but that was the situation. And we've had all of the trips to Strasbourg in relation to fatal fetal abnormalities and the like. I mean, we've gone through all of that, and we've come now to a situation where we're addressing the issue to fair and square. And I just want to make this point in relation to what we're about. Senator Wilson makes the point, what's so special about 12 weeks? And so does Senator Mullen. And of course, in one sense, 11 or 13, they're somewhat arbitrary, time periods in one respect. But let's also recall the medical truth, and that is that, after 3 or 4 weeks, we are dealing with a cluster of cells that is a couple of millimetres across, and it begins to pulsate, to circulate to circulate fluids within it to maintain its existence and to keep the development process going. And we're told that's a heartbeat. Well, you can say it's a heartbeat, but there isn't really a heart at the earliest stage. But up to 8 or 9 weeks, we are dealing with a developing embryo which grows from the size from being tiny to the size of less than your finger over a number of weeks. And that's the period of time that we're dealing with. We're not dealing with a fetus that any ordinary person looking at it, if it was miscarried, would say, there is a person. What you would say in such sad circumstances is, there was the seed or the potential for a person to exist. And so many mothers have been in that sad position after miscarriages. But the law, in my respectful view, should not be perverted, and the Constitution should not have been perverted to regard that fetus at that stage of development as a human person, in the sense that we actually accord the term person meaning. So I just want to make the point in relation to what this section is doing, that we are removing from the Constitution a very contradictory set of statements, which started in 1983 with what I believe was an untrue statement, that the unborn was a person with the same and equal rights as the mother, which, when it came up against legal realities in the X case, had to be reversed by the people by constitutional amendment to reverse the idea of equality and to say that we will treat the unborn differently from a born child. And that's what we did, because as I said earlier, nobody in their right mind would change the Constitution to say that parents can bring their baby to England, their born baby to England, to have that baby killed. Nobody would do it. So the Irish people actually were making their own judgment on these matters. And we've now got to the point that we see all the problems which still flow from the fundamental untruth that a zygote or a fetus at an early stage of its development is to be regarded as an equal person with a child just about to be born or whatever. We've got to that point that we have to confront the problem which arises from that. And they are serious problems. And legally they are serious problems. And I say this in all seriousness, that what was wrong with Article 43.3, and when Peter Sutherland pointed out what was wrong with it, was that it was going to have inevitably these consequences because it wasn't telling the truth. And it wasn't admitting that we were dealing with a grey area. It was saying it's black and white, it's simple, just vote for it, and everything will be all right. There will never be abortion in Ireland. And it failed. And because it failed, and because it is an obstruction, and because the recent legislation is, and I'm not going to use the word a dog's dinner, but it is not satisfactory. It is not satisfactory either. And everybody, I think, knows that it's not satisfactory. And everybody knows that it's not a maintainable or sustainable point of view. And let's remember, again, the people who are against repeal of the Eighth Amendment vigorously opposed the legislation that was supposed to regularise the post-X case decision. And they were entitled to do so. I don't criticise them for that. But it's not as if the status quo is what they wanted to defend. They wanted to defend a very different, simplistic Article 43.3 as they originally intended it to be. So I want to make this point, that we're not simply just putting in the wording to which we will return when we get to the schedule. We are removing Article 43.3. And we are bringing Ireland back to the position it was in 1982. It was not a bad position in one sense, because the legislature at that time had the freedom to deal with abortion, termination, rape and all the rest of it as it saw fit. And what was done in 1982 at the behest of people who were worried about a Roe and Wade decision from the courts was to take away the power from the legislature to bring in laws to deal with that situation. And I think that's a very serious problem. The last point I want to make is this. Senator Mullen said last night, he said, you know, we have an infanticide law which differentiates between an early, a mother in post-delivery and the rest of humanity when it comes to the law of homicide, and takes account, it used to be on the basis of a crazy theory that it had something to do with the effect of lactation on the mother's mind, but it now, in its modern form, just simply deals with the fact of postnatal depression and issues of that kind. That is true, but it's still a crime. And what Senator Mullen advanced yesterday for our consideration was the possibility that with a humane and decent DPP, no girl would ever be prosecuted for taking the abortion pill. Well, I'm saying this, that if we keep Article 43.3 in place, and this is a point that I hadn't time to make yesterday, you can't decriminalise abortion. The courts would say that that is unconstitutional. And you can't say, we'll turn a blind eye to this and turn a blind eye to that. You can't do it. And you can't turn a blind eye. If somebody gives somebody else an abortion pill, you can't turn a blind eye to that set of facts and at the same time claim that you are upholding the right of the unborn as far as is practicable and defending and vindicating that right in future. You can't do it. And in Belfast, we know that a girl was prosecuted for taking the abortion pill because her flatmate got a pang of conscience and told the police about it, and the poor girl was interviewed about it and admitted it. And she was prosecuted for that. I mean, let's not kid ourselves. What leaving Article 43.3 in place actually involves, and I say this in all sincerity and with all conviction, is requiring it to be a crime to take an abortion pill, and requiring it to be a crime to assist somebody in taking the abortion pill, like going to England to get it or going down to the chemist shop to get it or whatever. You cannot decriminalise that activity and keep Article 43.3 in its present form. And therefore, to those people who say, you know, that the Constitution is there to set standards and it's not there to deal with the hard cases, I reject that idea, because in the end, we remember the poor girl in the X case, who, a rape victim, was hauled back from England by the courts because that was the law. And we remember that girl in Belfast who found herself dragged before the courts because she had taken the abortion pill in Belfast, where it's criminal to do it. And there is no, if we're going to say there's nothing grey between a cluster of cells in a petri dish in a laboratory, and there's no distinction between that and a human being. If we're going to make that point and say there are no shades of grey, there isn't a developmental process, there isn't a spectrum of development within which the victim of a rape is entitled to take steps to end a pregnancy. If that's our position, and it's going to be a crime and must remain a crime for the victim of a rape in Ireland to end her pregnancy, which is what not deleting Article 43.3 necessarily means. If that's our position, so be it. Stand on that. But the consequences definitely are that that is what you're standing for. It will be, if this referendum is defeated, it will be a crime for a victim of a rape in Ireland to take an abortion pill to end the pregnancy. It will be a crime for anybody to give it to her. It will be a crime for anybody to assist her in getting it. They will all be criminals before our law. And if you say to me, it won't happen, it has happened in Belfast. It has happened. And tell me why it shouldn't happen here, if that is not merely part of our criminal law, but part of our criminal law which is necessitated by the terms of the Constitution itself. So I ask you, fellow members of this House, I ask you to consider carefully what keeping Article 43.3 actually means. We are in exactly the same position as our predecessors in 1983 were when they enacted the pro-life amendment, the Eighth Amendment. We are making a decision which will have definite legal and criminal effects. There will be outcomes. And you can't just simply say, I'm against 12 weeks. Therefore, I want it to continue to be a criminal offence for a girl to take the abortion pill in Ireland after a rape. That's what I want it to be, and that's the price I'm willing to pay to keep the Constitution as it is, because that price will be paid by some girl. It was in Belfast, and it will be. And the same applies to any way you can try and develop the law in any way to deal with exceptions such as rape. And what I believe the committee in this House and the Citizens' Assembly, whatever the faults that other people have about those processes, I think they faced up fair and square. You will never be able to have a process that will determine whether a girl was raped in time for that girl to take any steps to defend herself. And we only have to look at what the news which came out from the criminal courts in Belfast today to ponder, how difficult it is for a rape to be established. And we only have to look at recent decisions of the Irish courts that there should be somebody who has sex while not using a condom commits rape with a woman who is willing to consent to it with a condom and consented to it on the basis that there would be a condom, to realise how impossible it would be to have a system other than a 12-week, no questions asked system to deal with those kind of hard cases. And by way of footnote, can I say this, Chairman? I've heard a number of people say, and I know exactly what they are trying to say. They said, my mother told me that she contemplated having an abortion. And if that had happened, I wouldn't be here today. It sounds like a very good point. But just think about it. If your parents had decided, you being the fourth in a family, we're only going to have 3, and had used contraception, you wouldn't be here today. The accident of our birth is incalculable when you think back about it. If your father had used a condom, if your mother had used a diaphragm or an IUD, you wouldn't be here today. It doesn't prove the fact that all of us must say that about ourselves, that if our parents had made a different choice, we wouldn't be here today. That does not prove that contraception is wrong, and likewise, it does not prove the case for retaining the Eighth Amendment. Thank you.
Senator McDowell. Next speaker is Senator Terry Layton.